Hi, everyone. We'll just take a minute here, a few more filtering in, and we'll get started in a moment. All right, let's go ahead and get started. Thanks everyone for joining. My name is Paul Rothermel. I'll be talking to you about 10 things that I've seen many times come up in my experience dealing with privacy, especially for life sciences companies, medical device companies, pharma in that space. So we'll walk through those items. We have 45 minutes, so we'll cover them in some speed, but we'll talk through that in a second here. And as we get started, just a little bit about myself. So, as many of you may know, my background is in privacy, of course, and so HIPAA, GDPR, various state and federal privacy laws. I've been involved in setting up HIPAA privacy programs, acting as a privacy officer for some of those programs, data protection officer for various companies with involvement in the EU, and a variety of other privacy activities, from audits to cybersecurity assessments, privacy risk assessments, and so on. So just a couple of things before we get started. So I want to talk briefly about where we're at in privacy in 2024. As anyone who's involved in the space knows, there's a lot of change, even month to month or week to week, in terms of what privacy laws have been passed, what sort of engagement we have to deal with on that front. So I'll give a brief just overview of where we are, both here in the US and globally, just a high level touch on that. And then from there, let's talk about what it is that you should know as a privacy lawyer who's thinking about some of the new issues that are pending, or even some things that maybe are older issues that we've dealt with in the past, but in light of some of the changes in privacy law, whether that's clinical trials, dealing with business associate agreements, those kinds of things. So again, these won't be exhaustive on every topic, but we'll deal with 10 things that I think are primary and important. And what I want you to take away from that is ultimately how to best deal with some of these issues or issue spot when it comes to privacy, and identify some of the gaps that you might have either in your awareness or things you can highlight for your company if you're involved in privacy. And of course, throughout, please feel free to ask questions. There's a chat function on the webinar tool, so go ahead and input questions at any time. What I'll plan to do is answer some of those questions at the end, time permitting. So many of you are probably paying attention to the news, and whether you read privacy news or not, you've probably seen a few headlines like this. I'm from Minnesota, so many of the folks here have been aware that a Minnesota comprehensive privacy law was passed not very long ago. In the past couple of weeks, we have privacy laws popping up in various states, from Maryland to Vermont to you name the state. There's been some activity, whether it's passage or a new bill proposed or something in the past few months, regulations being drafted and so on. And we have some enforcement going on, although that's nascent. There's a little bit going on, especially in California, that we see in terms of enforcement, some on certain biometric privacy laws in Illinois and so forth. But that surely will increase, over time as these laws become more mature. And just to kind of get up to speed, state privacy laws have been passing at a high rate over the past year or two. You can see here a list of states where, either a comprehensive privacy law, i.e. one that covers broadly personal information in the state, or more specifically, and I think this is relevant to our industry especially, privacy laws that address consumer health data. So we have one that's specifically designed for that in Washington, we have one in Nevada, and then Connecticut has adopted some revisions to its comprehensive privacy law that address consumer health data specifically. So we're paying attention to those as well. In today's program, we're going to mostly focus on some key elements of California law, noting that at a high level, there are some changes going on there, and things worth noting that have trended in other states. And then as another case study, we'll look at some law in Washington state around consumer health data, which is relevant to kind of generally how we approach consumer health information that's regulated at a specific level. Of course, we have federal privacy law. Among these that we'll focus on, we'll mainly be looking at HIPAA today in terms of application and the healthcare industry, and that's really relevant. There are other relevant laws, the Federal Trade Commission Act that covers consumer protection, CAN-SPAM or the Email Marketing Act, Telephone Consumer Privacy Acts around text messaging, phone calls, and things related to marketing and children's online privacy. There's a lot of other considerations, but we're going to focus on HIPAA applicability today. And of course, outside the US, there is a lot of activity. And we won't go deep into much of this, but I will note a few GDPR considerations that are really relevant to life sciences companies in the US that do business primarily in the US, but may have some operations that impact Europe. And we'll talk about that briefly as well. So let's get started. There are 10 things we want to get through the next 35 minutes or so. So one of the things I think that we sometimes miss in just approaching privacy is personal information. What is it? What are we talking about? So we'll look at a few different examples of laws that discuss personal information and how it's defined and what sort of considerations we should have when we look at these laws. So of course, HIPAA, a great example of a sector-specific law that focuses on data that's in a particular sector. So we know that HIPAA applies to covered entities, to business associates. So that's one of the first things we'll think about when it comes to HIPAA is what applies. What does it apply to? What kind of entities? But then from that, it applies to certain kinds of data. So if you're operating as a durable medical equipment manufacturer, or you have a laboratory or some sort of covered entity product or business model, this is very relevant to you, and you'll want to think about what is the information that we have that's protected by HIPAA in particular. I'll note here that it's pretty broad as far as health information within a covered entity or a business associate activity, but it does exclude certain things. So employment records, educational records protected by FERPA. Probably most relevant to us is employment records, and then also noticing that records about deceased individuals after 50 years are no longer protected by HIPAA as well. So that's a single definition of personal information. And I think the most critical thing is to realize this only applies to covered entities and business associates. HIPAA is not a broad brush, all health information kind of law. And that brings us to another example. So this is one of the reasons that states have taken on regulating healthcare privacy laws and so on, and consumer health data, comprehensive privacy laws. California is one example that focused on all consumer information. And this is interpreted much more broadly than simply someone who's seeking to buy a product. Consumer can include employees, it can include business-to-business activities with other salespeople at other companies or contacts, those kinds of things. So personal information in California has a broad definition. And you can see that in that highlighted, bolded and underlined section that says information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So it even goes beyond simply an individual consumer. What if it's a household that's being identified? So an address, a particular location. So we have to kind of think of personal information as a broad category, especially in in these comprehensive privacy laws like in California. There's some examples here from the statute, and I won't read all of them, but I just want to point you to things that you might not necessarily consider to be personal information. So that second bullet from the bottom is inferences. So if you take personal data and create an inference about someone, it's not actually data about them in the sense that it's factual, hard information, but it's an inference that's drawn from data. So think about that in terms of data scope. So these are laws designed to cover a lot of possibilities and address them broadly. So we'll look at a consumer health data law and give another definition of personal data. And this is, again, more focused. Consumer health data is a kind of developing category of law. We only have seen a few of them so far. But the focus here is information that relates to someone's physical or mental health and the status of that. So many examples are given here. And again, I won't dig into all of them, but merely point out that this is fairly broad. Personal information that's linked or reasonably linkable to a consumer. So that could be, data that's directly linked to an identifier, or information that's somehow linkable to a person, to an identifiable person. And again, it's not necessarily that it's directly about their information, their health information, but it could be something that infers something about their health. So we won't look at it today, but there's an example and some guidance from the Washington Attorney General that says essentially, sure, buying toiletries, things like that, those kinds of data, those aren't personal consumer health data on their own. But if you use purchases of consumer products and so on to create an inference about someone's health, okay, now the inference becomes personal data under this statute. So that's something to keep in mind as well. So what is personal information in let's say Europe? Now, we know from kind of the history of these laws that California's Consumer Privacy Act generally kind of borrowed some concepts from the GDPR, and that's evident here. The GDPR has a very broad definition, again, of individual identifiable personal data. It's any information that relates to an identified or identifiable natural person. So obviously about a corporation, not personal data, but about an individual, yes. And that includes employees, it includes business contacts, it includes any broad number of individuals. And I will just point out that something that is done in both GDPR and many other privacy laws, there's sometimes a special category or an additional kind of sensitive information, sensitive personal information definition that creates a heightened protection for that kind of data. So that would be one example here where health data, data concerning health is addressed. So what's really key about all of these definitions, and what I want you to take away, is personal data can include a lot of things. So make sure that your company's privacy program takes into account all of those definitions and that apply to your company or business and properly addresses them. So make sure that you don't have a privacy policy that only addresses consumers or only addresses patients or only addresses HIPAA. There's a lot more at play right now. So the second thing I want to share, and I think this is something we see frequently, is when do laws like HIPAA or privacy laws apply to clinical trial data, or do they at all? And let's talk about that. So data collected by a sponsor in a clinical trial is often not regulated by HIPAA and often not regulated by data privacy laws in states. And the reason for that is HIPAA applies only to covered entities and business associates of covered entities. If you're not familiar with these entities, covered entities are healthcare providers, health plans, healthcare clearinghouses, and specifically for healthcare providers, it's those that bill insurance electronically. So those are your typical practices, doctors, and then certain medical device companies might qualify, or laboratories if they, again, directly bill insurance rather than a provider billing insurance for a product sold to them. Business associates are a service provider that provides services to a covered entity. So that really, for the most part, is going to exclude clinical trial sponsors who are in industry. So if you have a clinical trial sponsor that's a pharmaceutical company or a medical device manufacturer, it's a sponsor, but it may not be a covered entity or a business associate. So we can kind of look to, and it's case by case, but look to those entities and say, well, it's not a business associate, it's not a covered entity, so HIPAA will not apply, and that means the clinical trial data has to have some other way to be received for that research activity. And usually that's going to be patient authorization, and in some kind of rare cases, there may be an exception through an IRB approval or something, but typically there's a exception that allows that data to flow to the sponsor, and it's the identified form, and then that is a non-HIPAA protected data set. So HIPAA would not generally apply. So what about data collected by a sponsor and state law? Are there applicability issues we have to deal with? Is clinical trial data going to be limited? Is there going to be deletion rights and so on? Well, typically no. And we see that as in examples here. The Washington My Health, My Data Act has a reference that says essentially that consumer health data is not going to include information that's used in certain kinds of research. And it explicitly outlines some of the criteria that have to be met in order for that to be true. But there is an exemption for clinical trials, particularly those that are governed by institutional review boards, where there's an ethics committee or something involved in oversight, and there's safeguards that have been implemented to mitigate privacy risks, those kinds of things, as you typically would see in a clinical trial. Similarly, California has its own version of this exception, but again, it's focused on, we don't want to get involved in regulating data that's under some other privacy governance framework, which in this case would be human subject protections, federally regulated human subject protections, and so forth. So that is an important thing to note, is that clinical trial data typically, and in almost all cases, if those trials are operated under these frameworks, would not be subject to these laws. Another key question we see very often in the life sciences space is, should my company sign a business associate agreement? Customers might ask for this regularly. What do we do? So I think the most important thing to point out is you should know before signing whether that agreement is going to be applicable. There are lots of exceptions to business associate agreements for medical device manufacturers, pharmaceutical companies, and those can include treatment-related disclosures, payment disclosures, healthcare operations disclosures in some cases. With patient authorization, there can be an exception. There can be public health exceptions when it comes to following FDA regulations. There may be some circumstances where a business associate agreement is appropriate. Maybe you have a cloud-connected product. Maybe you have a product support program of some kind, or prior authorization support, where there's more of a service-related activity that involves PHI. There may be situations where that's true, and that's important to evaluate. But generally speaking, on its own, simply providing a product that may involve some interaction around a patient's data does not on its own make a manufacturer subject to these business associate requirements. So there is a FAQ number 490 that outlines in some detail the government's thinking on this, specifically around medical device manufacturers. So it's a long FAQ. We won't read it all here, but in some, you can see it here. There's essentially an exception-based framework where you can look to these other exceptions and identify the legitimate uses of data within the context of these relationships, where you don't need a BAA or business associate agreement. What about clinical trials? So this is a common issue or question that comes up for us. If we have a US clinical trial sponsor, we're dealing with, maybe it's a new drug or it's a new therapy, maybe it's a brand new device, and we're doing a clinical trial. We want to know, how is this working? And a great location to do studies at times is Europe. So what if we have a clinical trial that's going on with sites in Europe? Does the GDPR apply to those? And obviously within the hospital setting, GDPR applies, that's clear, but when we have the key coded or pseudonymized data flowing back and forth to our US company, we're dealing with vendors here in the US and so on to process that data. What do we do? Is GDPR applicable? So the number one thing to note here is that US companies conducting audits or activities in Europe can fall under what's called an extraterritorial scope of the GDPR. And generally the idea is if you have business in Europe and you're doing operational activity that looks at patient data in Europe or pulls patient data from Europe, whether or not your business is located there physically is not really relevant. It's the activities that you're pursuing. Especially in today's digital age, that makes some sense, that companies can be located anywhere but still have some business presence in a location. And there's an example in the guidelines that I noted here that, hey, there's a clinical trial sponsor in India. They have some clinical studies in some EU member countries, Belgium, Netherlands, etc. Yes, there is definitely a link. They're processing personal data of EU subjects. They're a data controller, and with that comes obligations that come from the GDPR. So what about this other aspect? Is key coded data or pseudonymized data, is that regulated by the GDPR? Yes, generally these are going to be personal data. These are not the same as anonymized data. Pseudonymized and key coded data in the view of the GDPR and the data protection authorities generally within Europe is that these are re-identifiable data sets that if you find a link to them, okay, now you can start to identify them. And one of the concerns I really think that the authorities have with this is you could, in theory, hire a vendor, give them a pseudonymized data set, do processing, and there's no culpability under GDPR if pseudonymized or key coded data is no longer protected. It would be, if it's considered anonymized. So again, there's a guidance that indicates, yes, pseudonymized and key coded clinical trial data that's handled by a sponsor is going to be subject to the GDPR. Here's another common question we see. So how do I know if HIPAA or state law, which one of these or both apply to my company's data? So I want to talk through some ways to analyze that and how we approach that. So HIPAA only regulates covered entities and business associates directly. So we need to determine if HIPAA applies to any of your company's data. So is your company a covered entity or a business associate? If yes, what about state law applicability? Are the criteria met? Is the information in scope of either HIPAA or state law? And if there is applicability under state law, so what if you have both to deal with? Maybe there's an exception that applies for PHI or for covered entities or business associates in that state law. So then you can look to that exception, identify exactly what is excluded. Typically, we'll show some examples of these in the next slide, but there are some ways that state laws have found to identify exceptions because they don't want to get in the business of conflicting with HIPAA, having to deal with preemption and so on. If there's not a covered entity or business associate, if you are operating really as a manufacturer, you have no additional obligations that are HIPAA, well, maybe there's state law that applies, maybe not. So look at the state law applicability criteria. Do they cover your company or the personal information in question? And then lastly, consider this: personal information that's received from covered entities or business associates is not necessarily PHI when it's handled by a manufacturer if that manufacturer is not a covered entity, not a business associate. So those state laws may apply here, even if you receive that information from a covered entity. So keep that in mind as you do these analyses. So another question that we see quite a bit, or issue that comes up, is around the difference between privacy notice and consent. One thing that we see pretty often is a confusion around, if I provide notice to an individual, is my privacy notice versus consent going to be accurate or not? And excuse me, I think I have the wrong slides here, so I'm going to pause for 1 second while I switch decks here. I think I have the wrong deck open. Thanks for the time. I just realized that I had an old slide deck open instead of the latest. So I want to make sure you get all of the details and aren't missing some information. So one more comment on the HIPAA or state law kind of applicability question. So here's just a couple of examples of that. So some state privacy laws exclude HIPAA covered entities and business associates or PHI. And that example here, so California Civil Code says protected health information that's collected by a covered entity or business associate is exempted. So that's a very clear exception. Similarly, the Washington My Health My Data Act exempts information that, quote, meets the definition of PHI for purposes of HIPAA. So one other comment, though, is that if state law does not provide an exemption, then you may have to look at both state law and HIPAA and identify, okay, we have potentially a preemption issue here, but HIPAA does provide what's called a kind of a more stringent standard. So if there's PHI that is going to be protected better by a state law, and it's not totally it's in conflict, but in a more stringent manner, better protection for that individual patient, then you'd have to look to state law as well and follow that. So we were just talking about privacy notice versus consent briefly. So here are a couple of remaining comments on that. So privacy notice is something you deliver upfront when you collect information. It's intended to give information, be transparent, but it's not trying to get an affirmation or express consent or a signature. It's designed to inform, to give notice. And on the other hand, consent is something that we typically see that's sought. We ask for something. It's an exchange. It's looking for a signature, a checkbox, something that affirms, yes, I consent to this. So a big difference here is if I go to a website, I'm typically going to, and there's some exceptions to this around cookies and so on, I'm typically going to be delivered a notice that says, you're using this service of ours, this website. Here's what happens when you do that. Here's a notice. So obviously, there are other activities that I might want to get involved in where consent would be more appropriate. Let's say I fill out a fillable form on the website and I input my phone number. By putting my phone number there, I'm not necessarily expecting to get a daily text from this website, right, or this website operator. But if there's a consent checkbox that says, yes, I understand if I click this box, blah, so there's an actual express consent element, that's a very different story. And that's why consent can be really important. But notice is also a critical part of this, and it does things like give notice of privacy rights and so on. So there's a big difference here, and it's important to note that consent generally is an augmentation or an additional element on top of giving notice. They're not kind of distinguished as the same thing. They don't do the same thing. They're individual and separate. Another common question, I think this is something that most folks who aren't deeply in the privacy world are probably unfamiliar with this concept or not very familiar. Unless you do a lot of GDPR work, this is a pretty new thing in terms of US law. So what kind of activities are privacy risk assessments? What does that involve? So we'll look at those. I think the best example to start with is let's go to Europe, where this concept kind of originated or we're most familiar with. A lot of guidance around it. So the idea is that you have certain activities where there's a risk, and we'll talk about that in a moment when that's appropriate. But there's a risk, so you identify that and you do an assessment. So the assessment here would involve, by regulation, seeking advice from the data protection officer, documenting a systematic description of the processing. So who's doing it, how is it being done, what kind of technology is involved, those sorts of things. Is this activity with data, this processing activity, is it necessary? Is it proportionate to the kind of purposes that were planned when you originally started this activity? Are there assessments of risks to the rights and freedoms of data subjects? Or maybe in the US, we think about it more like is there risk of harming a data subject or to their privacy rights? So you'd look at these kind of assessment of risks to individuals, and then document measures that address risk, that safeguard privacy, that prevent security breaches. Document those things. And ultimately, all of that is produced and documented. And really, anytime there's a major change in that processing activity, you would produce one of these. Or in some cases, based on a regulatory basis, submit regularly to an authority of some kind. Yeah, we've looked at this and we have a documented risk assessment on file. So when are these supposed to be completed? Well, in Europe, for example, this is a common activity when there's what's called high risk processing, or where a type of processing is likely to result in a higher risk to the rights and freedoms of a person, right? So you have various ways that this has been interpreted, but there are some guidance documents out there, and one of the primary guidance documents has these 9 criteria to consider. But basically it's things like, okay, we want to create a kind of like a credit score kind of approach, like we want to evaluate or score or profile or predict behavior of individuals using personal data, probably a high risk activity. We want to use, let's say, an automated decision-making tool, so something that absorbs personal information, but then produces a very specific outcome. Often, let's say you submit for a housing loan, or you apply for a job, or different things. If there's an automated system that produces some outcome, there's a concern that personal data is used appropriately. So let's do some risk assessment on the front end. Various other activities, but most critical, I think, for life sciences would be things like large scale processing. So very often, let's think of that clinical trial example. Large scale has relevance to not only the volume and number of subjects, so it doesn't have to be thousands and thousands or millions. It also takes into account duration and permanence of processing. In clinical trials, often we process data for very long periods of time after and maintain that data long after the trial is complete. We also have geographical boundaries that we cross, and we might do a study in Europe while we're based in the US. So we have to think about that from that perspective. We might match and combine data sets. That's a common approach. So you might take data set X from this study, data set Y from this study, and kind of do some cohesion and evaluation there. There often can be vulnerable data subjects in clinical studies. And then beyond that, there's limited rights that patients might have during a clinical study. They might not be able to access information the same way that they would during even normal routine healthcare. They might not be able to ask for a deletion or other things that are typical in their privacy rights in Europe. So these are all examples of criteria. So let's look at a US example of what is a privacy risk assessment. And there are a few examples that have come out now. I want to use California because we've been looking at them throughout this presentation already. But Colorado, Connecticut, many other states have also implemented privacy risk assessment or data privacy impact assessment frameworks. So just briefly, the statutory language right now basically indicates that there's going to be a regulation written that requires these and gives parameters for them. Right now, that regulation's not fully proposed even. It's in a draft that's being discussed. So we'll wait on that for now. But the idea is essentially that we'll have something that looks at, is there sensitive personal information involved, identifies and weighs, is there benefit of this processing for the business, for consumers, for the public and the other stakeholders, and then weighs that against what kind of risks are there to consumers if we process data this way. And then if there are risks that outweigh benefits, there could be some curtailing of that. And these would have to be reported on a regular basis to the California's Consumer Protection Agency. So that's our Privacy Protection Agency. So that's one aspect of this that's key to note. Right now, the draft, I won't read through it, but you can see there's some elements that kind of sound like what we saw in Europe, where we have to document, what kind of processing is it? Is it this kind of information or that kind of information? What's the context? Do consumers have reasonable expectations based on how the data was collected or the purpose for processing? And then is this purpose and process compatible? So they thought their data was being collected to help them buy a product from the company, and now it's being used for X, Y, or Z. Is that compatible with that original purpose? So there's a lot of different elements there. Not going to dive into them. They're still just a draft discussion, but it is interesting to see that kind of prepared and considered right now. So in this California reg, when do we need to complete one of these? Well, right now the standard is when processing of consumer personal information presents significant risk to consumers' privacy or security. So that's very broad. We don't really know exactly what that will mean until the regulations are completed. We can probably take some guesses. So just a few more here in the last few minutes. So a personal data inventory, and really what this is taking stock of what personal data and information do we have in our company? Where is it? Who's responsible for it? What systems is it in? What's it being used for? It's an inventory. It's kind of taking stock, understanding what's there. There are some legal requirements to do this. Particularly GDPR, of course, has what's called a record of processing activities. I won't get deep into it, but you can see some of the criteria to meet here. And this applies to data controllers, and it also can apply to data processors, although on a little more limited scale if they're merely processing data as a service provider. But this is a key element of GDPR, and it flows into many other requirements. In Washington, with the My Health, My Data Act, if you process consumer health data from Washington citizens or residents, then you have to know, at least to an extent, what's happening with your personal data. And even though it doesn't explicitly require a data inventory in those terms, if you're going to go and identify categories of consumer health data that's collected, how it's used, for what, the categories and sources from where that's collected, you really need some sort of way to inventory that data collection, or it's not going to be complete, that data collection and use. So it's important to have this in your mind as what do I need to do to comply with these laws, even if it's not explicitly laid out here. And similarly, and I won't have a slide for this, but California, we have the Consumer Privacy Act that requires these risk assessments. When we get to the point where those are clearly defined, how are you going to show a regulator, I did my due diligence and identified high risk processing, if you don't have some sort of list of processing activities? Without those activities listed somewhere in that record of here's the data that we have, here's what it entails, the type of data categories, identifying high risk processing is going to be really difficult. So I think it's obvious that this is a key part of any privacy program, regardless of the laws that you're dealing with. Even HIPAA has reference to this kind of activity. So it's really key. And this says number 8, but it's number 9. Do we need privacy terms in vendor agreements? So a key thing to point out here is GDPR, of course, requires this. I think everyone's who's involved in that knows there's a data processor, there's a data controller, and for that to be compliant, there needs to be language in agreement that outlines how is personal data processed and what are the parameters for that. So the elements of those requirements are here. Maybe less known is that the US has some similar requirements. So California's Consumer Privacy Act has this requirement. And this is, again, pretty similar, I would say, to the kinds of elements that GDPR requires. You know, are there personal information? What kind is it? How is it to be used? Is it limited? Does it obligate that third party to follow the CCPA and as amended and as the regulations? Does it do that? Does it grant consumer privacy rights? All those things through that contract. So pay attention to these requirements and look at those that are relevant to your business in other states. Washington. So in the consumer health data space, this is also relevant. We see requirements to document requirements in an agreement for privacy. So pay attention to that, evaluate your agreements. Are they going to cover personal data as well? One other key area, and this is going to be brief, but does a life sciences company have to report data breaches? When does that happen? Well, much like any other business, there are a few different ways that this comes up. Many state laws can be triggered by any kind of data breach. There are 50, maybe even 51 state data breach notification laws, and each of them is triggered differently. There are different variable definitions on requirements, on timing. So things to look at that are key, and consult local counsel, but consider your breach definition. What is the breach definition in that statute? What are the reporting triggers? Sometimes there are exceptions. Sometimes there are shorter timelines or longer timelines, depending on the state, depending on the body you're notifying, whether it's individuals, government agencies. And there's even different definitions of, again, as we talked about at the beginning, personal information. So what is it that's reportable? Can vary so widely across these laws. Beyond that, we have the FTC health breach notification rule, and really one of the main purposes, although it's not the only purpose of this rule, is to ensure that things like mobile health apps, different ways that health information is used and disclosed outside of HIPAA regulated entities, that these are protected through this breach notification rule. Beyond that, the HIPAA breach notification rule, of course, applies to covered entities and business associates. You have very specific timeframes, very specific breach definitions, very relevant to entities that are involved and have HIPAA applicability. Something newer that we're seeing is various other federal bodies getting involved in breach notification reporting requirements. The Securities Exchange Commission has had recent rulemaking, and some of these require disclosures either annually or even within, in one case, 4 business days of a material security cybersecurity incident. So you could have requirements that go way beyond just notifying regulators. You may even have to notify your shareholders. So there's a important note here as well on breach notification, and the ramifications for that are clear. We can point to some examples and even recent case law on that. And then, of course, if you have a medical device or a connected device, pay attention, software as a medical device, pay attention to whether any kind of breach might also impact safety and efficacy of that device. So, of course, look to federal guidance from the FDA on this and be ready to notify those appropriately too. Kind of a final quick comment here, and then we'll close. So what about a deletion request from a consumer? These come up way more often than we realize. They often include, I'm so-and-so, I'd like you to delete all the data you have on me, or I'd like to know what it is and have you delete it. So typically these come from two different angles. Sometimes you have a company that's clearly regulated, maybe it's by GDPR. Look to that law, identify what you're obligated to do by that law, but then look also at what other maybe competing interests are there. Are there litigation holds, government investigations? Do you have medical record retention requirements, clinical trial data retention requirements? Is it FDA regulated data? Pay attention to those exceptions before jumping to delete data, of course. And then also pay attention, does this privacy law itself give an exception? That's actually fairly common. In the US, we have an example of California that I'll briefly show on the next slide, but there are different ways that these can be accepted. But also respond in a timely way, whether you agree to delete the data or not. Make sure that you're communicating that to the data subject. Here's that example of exceptions that might apply. Okay, so I think just to wrap up, I want to give a few quick takeaways before we answer questions, but ultimately what we're trying to do is be informed, be aware of some of the common issues in terms of privacy that we see, and better understand what is it that it takes to operate a privacy program. With the many different laws that we see coming out, even month to month these days, having a program in place rather than simply ad hoc trying to comply is really key. So having a process for updating your privacy policy when something changes, evaluating that against the new laws and trying to be at least substantially compliant with those. And then paying attention to things like privacy risk assessments. These are newer and challenging topics where there isn't necessarily a tried and true method, but we're able to draw on things like the GDPR experience that we've had and other areas to implement within the US as well. And then ultimately, just be wary of jumping to sign business associate agreements too. That's an area that life sciences companies can get pulled into, by convenience. But there are a lot of risks associated with signing BAAs, and especially when they don't apply. So be aware of when that should be signed or when it should be pushed back on. So again, I hope this is very helpful. I'll take a couple minutes to just look at some questions if there are any. It looks like right now we don't have questions. Feel free to ask one now if you do have one. But again, thank you so much for your time, and I hope you enjoyed the session. Happy to take questions by email too if you happen to have them after the session. All right, thank you.